Imagine waking up one morning, checking your phone, and seeing a notification that changes everything. Your green card application, the one you've been waiting on for years, maybe even a decade, has been affected by a new rule you never heard of. Nobody told you. Your lawyer didn't warn you. And now you're scrambling, trying to figure out what just happened and whether everything you worked for is suddenly at risk. This is not a hypothetical. This is the reality that thousands of immigrants across the United States are facing right now in 2026. New immigration rules are being rolled out, some quietly, some loudly, all of them with real consequences for real people who came to this country with a dream and a plan. And today, we are going to break down every single thing you need to know, clearly, honestly, and completely, so that you are never caught off guard. Welcome to USA Visa Explained. If you are new here, this channel exists because the American immigration system is one of the most complicated legal systems in the world, and most people navigating it are doing so without the right information. We don't do vague summaries here. We don't do clickbait without substance. When we say there is something you must know, we mean it. And today's topic is one of the most important we have ever covered. So stay with me from beginning to end, because missing even one part of this video could cost you years of progress and thousands of dollars. Let's start with the big picture, because context matters enormously here. The United States immigration system has been under intense political and administrative pressure for several years. Ever since the pandemic reshaped how governments think about borders, labor markets, and national security, there has been a steady push to reform, tighten, and restructure how green cards are issued, processed, and maintained. In 2025 alone, there were more proposed immigration rule changes than in any single year in the past 2 decades. And as we enter 2026, many of those proposed changes are now becoming real policy, with immediate effects on applicants, visa holders, and even people who already have their green card in hand. What makes this particularly dangerous is that the changes are not all announced with fanfare. Some are buried in Federal Register notices that nobody reads unless they are an immigration attorney. Some are administrative policy shifts that don't require congressional approval. Some are court decisions that quietly alter how existing rules are interpreted. And some are genuine legislative changes that have been passed and signed into law. The result is a patchwork of new realities that, if you don't understand them, can trip you up at the worst possible moment. So let's go through the most critical green card-related changes for 2026 one by one. The first and perhaps most talked about change involves the public charge rule. This rule has a long and complicated history in American immigration law. At its core, the public charge rule is designed to ensure that immigrants who come to the United States do not become primarily dependent on government assistance. But the definition of what counts as a public charge and which benefits are considered disqualifying has shifted dramatically over the past few years. Under the current 2026 framework, immigration officers evaluating green card applications are now using a more comprehensive totality of circumstances test. This means they are not just looking at whether you have used a specific government benefit. They are looking at your overall financial situation, your employment history, your health, your age, your education, your skills, and your family situation. The goal is to assess the likelihood that you might need government support in the future. What this means, practically, is that if you have ever used Medicaid, with certain exceptions for emergency services, pregnancy, and disability, it could now be weighed more heavily against your application than it was in previous years. The same applies if you have received food assistance, housing vouchers, or other means-tested benefits. This doesn't automatically disqualify you, but it adds a layer of scrutiny that wasn't there before in the same way. For those of you who are currently on a path to a green card and have used any government assistance during your time in the United States, This is the moment to sit down with an immigration attorney and honestly review your history. Don't wait until you file. Don't assume that because you've heard the rule change back and forth, it won't apply to you. The current standard is real, and it is being applied. The second major change in 2026 involves the interview requirement expansion. For years, certain green card applicants, particularly those applying through employment-based categories, were routinely exempted from in-person interviews. Their applications were adjudicated entirely on paper by USCIS officers without any face-to-face meeting. This saved time and resources. But in 2026, that has changed significantly. USCIS has expanded the interview requirement to include far more applicants than before. Employment-based green card applicants in several categories, including EB1, EB2, and EB3, may now be called in for interviews that were previously not required. The interviews are designed to verify the information in the application, confirm the legitimacy of the employer-employee relationship, and assess the applicant's admissibility. This matters for several reasons. First, it adds time to the process. If your application was moving along on a predictable timeline and suddenly you get an interview notice, your clock just got reset in some ways. Second, it requires preparation. An interview is not just a formality. Officers ask detailed questions about your job, your qualifications, your employer, and your background. If your answers don't align perfectly with what's in your application, it can raise red flags. Third, it means that any inconsistencies in your paperwork, even minor ones, could become the focus of an interview conversation and potentially lead to a request for further evidence or, in worst cases, a denial. If you are in an employment-based green card process and you receive an interview notice in 2026, do not take it lightly. Prepare thoroughly. Go over every page of your application. Make sure you understand what was submitted on your behalf. If your employer's immigration attorney filed everything, request a full copy of the file and review it yourself. This is your application, your future. You have every right to understand it completely. The third critical change involves what is being called the continuous residence and physical presence clarification. This affects people who already have their green card and are either maintaining it or on a path to naturalization. A green card gives you permanent resident status, but permanent does not mean unconditional. You are expected to maintain the United States as your primary country of residence. You are not supposed to abandon your residency. And in 2026, there is a heightened level of scrutiny being applied to returning residents who have spent extended periods outside the country. Previously, a trip of under 6 months was generally considered safe. Trips between 6 months and 1 year required some explanation, and trips over a year required a re-entry permit obtained before departure. These general rules still apply, but the way they are being enforced at ports of entry has become notably stricter. Customs and Border Protection officers in 2026 are asking more detailed questions, reviewing travel histories more carefully, and in some cases referring returning green card holders to secondary inspection for seemingly routine trips. The factors they are looking at include how long you were outside the United States, how often you leave and return, whether you maintain a home in the U.S., whether you pay us taxes as a resident, whether your immediate family is in the U.S., whether you have a U.S.-based job or business, and whether all of your ties point toward the United States as your real home. If you are a green card holder who travels frequently for work, has family abroad, or has been spending significant time outside the country for any reason, 2026 is the year to reassess your situation. Get a re-entry permit if you plan to be abroad for more than 6 months. Keep documentation of your U.S. ties, lease agreements, bank statements, tax returns, employment letters, and be prepared to explain your travel history clearly and honestly if you are questioned at the border. The fourth change that is causing significant concern in the immigrant community relates to the national visa backlog and the new priority date movement policy. If you are in an employment-based or family-based green card backlog, you are familiar with the concept of priority dates, the date your petition was filed, and your place in the queue. The Visa Bulletin, published monthly by the State Department, tells you how the line is moving. In 2026, a new administrative policy has been introduced that affects how priority dates are calculated and how certain categories advance. Without getting too deep into the technical details, the practical effect is that some categories that were expected to move forward have either stalled or, in certain cases, retrogressed, meaning they moved backward. This is not new in the history of the Visa Bulletin, but the 2026 retrogression has caught many applicants off guard because it comes at a time when many were close to becoming eligible to file their final green card application. For those in the India and China employment-based categories, this is particularly painful. These backlogs are already measured in decades for some priority dates. Any further retrogression extends the wait even longer. And any policy change that affects the calculation of available visa numbers has downstream effects that compound over years. What can you do? Monitor the Visa Bulletin every single month without fail. If you are working with an immigration attorney, make sure they are on top of this and communicating with you proactively. Do not make major life decisions, buying a home, changing jobs, relocating, without first understanding where your priority date stands and what your options are under the current rules. Speaking of changing jobs, let's talk about the fifth major development, the Portability Rule Update. Portability is a provision that allows certain employment-based green card applicants to change jobs or employers after their application has been pending for 180 days or more without losing their place in line. It was designed to give applicants more flexibility and freedom in their careers without sacrificing years of progress toward a green card. In 2026, USCIS has issued new guidance on how portability works and what types of job changes are permissible under this provision. The key update is around what counts as the same or similar occupational classification when changing jobs. Previously, this was interpreted somewhat loosely. The new guidance tightens the standard, requiring a closer alignment in terms of job duties, required skills, and occupational classification codes. This matters enormously if you are in a job you want to leave or if your company is going through layoffs. If you are planning to use portability to switch employers, you need to get a professional opinion on whether your new role qualifies under the updated same or similar standard before you make the move. Making the switch and then finding out that portability doesn't apply could jeopardize your entire green card case. Now let's address something that affects a group of people who often don't realize they need to be paying attention: conditional permanent residents. These are individuals who received their green card through marriage to a U.S. citizen, where the marriage was less than 2 years old at the time of approval. They receive a 2-year conditional green card, and they must file to have the conditions removed within a 90-day window before the card expires. In 2026, the processing times for the I-751 petition, the form used to remove conditions, have extended significantly due to increased application volumes and the new interview expansion mentioned earlier. What this means is that if you file on time but your case takes longer than 2 years to be processed, you need to make sure you have proper documentation of your pending case to continue working and traveling legally. USCIS issues receipt notices and can extend your status automatically, but you need to understand how this works and keep your documentation current. There have also been reports of increased scrutiny on cases where the couple is no longer together at the time of filing, which requires a waiver. The standards for approving these waivers have not changed officially, but the level of evidence required to demonstrate that the original marriage was bona fide, real, and genuine has increased in practice. If you are in this situation, get legal help. This is not a do-it-yourself filing in 2026, Let's now talk about something that many people overlook, but that is absolutely critical: the consequences of criminal records and civil immigration violations on green card applications and renewals. In 2026, there has been a significant push to cross-reference criminal databases, tax records, and civil violation records against pending green card applications. Things that might have slipped through the cracks in previous years are now being flagged more reliably. This includes minor drug offenses that were expunged, DUI convictions, domestic incidents that resulted in arrests even without convictions, and certain civil violations including tax issues. Immigration law treats criminal history very differently from criminal law. Something that was resolved with a fine or a brief probation period in state court can have serious consequences in an immigration context. If you have any kind of legal history, no matter how minor you think it is, disclose it to your immigration attorney and get a proper assessment of how it might affect your green card case under 2026 standards. We are getting close to the end of this video, and I want to spend a few minutes on something that ties everything together: the importance of staying proactive in 2026. The changes we've discussed today are not designed to make your life easier. They are designed to make the system more rigorous, more scrutinized, and in some ways more uncertain. The applicants who will survive this environment and ultimately succeed are the ones who stay informed, stay prepared, and stay connected to good legal counsel. That does not mean you need to be in a constant state of anxiety. It means you need to treat your immigration journey like the serious legal matter it is. Keep copies of every document you file. Keep records of every communication with USCIS. Keep track of every deadline, receipt dates, biometrics appointments, interview notices, RFE response windows. Do not miss anything. And understand that the rules can change faster than any single source can keep up with. That is why you need multiple sources of information: official USCIS announcements, Federal Register publications, court decisions, and trusted educational channels like this one. Use all of them. Cross-reference what you hear, ask questions, and never make a major decision based on what a friend told you or what someone posted in a Facebook group. Let me close with something personal. Behind every green card application is a story. It's the story of someone who chose this country, who invested in this country, who is building a life here. And the rules, as complicated and as frustrating as they can be, are the framework through which that choice is recognized officially. Understanding those rules is not just a legal necessity. It is an act of respect for your own journey and for everything you have sacrificed to be here. The green card warning of 2026 is real. The changes are real, but so is your ability to navigate them if you have the right information, the right support, and the right mindset. If this video gave you clarity, helped you understand something you were confused about, or made you realize there is something you need to check on right away, then please do one thing: share it. Share it with someone who needs it. A coworker who is waiting on their green card, a family member going through the process, a friend who has had their green card for years and thinks they don't need to pay attention anymore. They do. You all do. Because in 2026, staying informed is not optional. It is your best protection. Subscribe to USA Visa Explained if you haven't already. Hit the notification bell so you never miss an update. And drop your questions in the comments below. Tell us where you are in the process, which category you're in, what country you're from, and what you're most worried about. We read everything, and your questions shape the content we create. Because at USA Visa Explained, we don't just report the rules. We help you understand what they mean for your life. And that is a promise we will never break. Thank you for watching. Stay informed, stay prepared, and keep moving forward. Your green card journey is worth fighting for.